Right, thank you so much, everyone. In case you don't, my name's Natalie Byram. I'm Director of Research at the Legal Education Foundation, and we're delighted to have you all here today and to have such a stellar panel to follow up our first stellar panel. So I've been asked by Hazel to apologise for the temperature in the room. We are trying to do something about it because I'm aware it's rather hot. But here with us this afternoon we have Shannon Salter, who is the Chair of the Civil Resolution Tribunal British Columbia and an adjunct professor at UBC Allard School of Law, where she specialises in teaching administrative law and legal ethics. In 2017, she was named one of the top 25 most influential lawyers in Canada and an Access to Justice All-Star. It's fair to say that our current reform programme has borrowed a lot from the work that Sharon's pioneered in British Columbia, and so I'm really looking forward to hearing what she has to say. We also are very lucky to have with us Dory Reiling, who is a judge at the Amsterdam First Instance Court and former IT policy officer to the Dutch judiciary and a senior World Bank judicial reform expert. Dory's published widely on topics covered at this conference and sits on a number of journal editorial boards, including the Hague Journal for the Rule of Law. And last but not least, we have Professor Dawn Chutkow, who is visiting professor of law at Cornell Law School. And she's the executive editor of the highly prestigious the Journal of Empirical Legal Studies. So without further ado, I'd like to hand over to Sharon to come and present her talk.
Thank you so much, Natalie and Dame Hazel, for the kind invitation to speak today. It's such a pleasure to be among so many guiding lights in the UK justice system. I've been very interested to follow the developments of your court reform program, and I'm hoping as I go along today I can highlight some of the pain points that we've suffered along the way, if for no other reason than to make you feel better, that these things are not easy at all, as Susan well knows. So I'll leave lots of time, of course, there's time at the end for questions, but I'm happy to talk at the break as well. If you have any questions, please just come up and chat. It's my favorite topic, as my daughters will tell you, to their chagrin. So the Civil Resolution Tribunal is, because it's a tribunal, part of our public justice system in British Columbia. British Columbia has about 4 million people, and it has about 27 administrative tribunals which specialize, as yours do, in particular areas, particularly usually with the regulatory state, but our tribunal is a bit different because we deal with party-to-party disputes between individual citizens rather than the government. And the reason I highlight that it's part of the justice system is because when we were launching, a lot of people thought this was a private ODR startup, like Modria used to be, for example, the kind of technology that eBay and PayPal uses. And I think it's important to highlight that it's part of the public justice system because that really changes your mandate. Your mandate then has to become, how do you create something that primarily uses technology, but as an access to justice project, disenfranchises nobody along the way. And so I'll talk a lot about that as I go. We were the first online tribunal in Canada, and as far as we know, the first one in the world, and that's why we were lucky enough to have a visit from Lord Justice Briggs a couple of years ago. He came all the way to Vancouver and Victoria, and we were really honored to be able to host him. I think some of my staff were worried he'd be wearing a wig, and they're very informal. He didn't wear a wig, and he charmed them all because he's so lovely and approachable. So we've had a lot of contact with Lord Justice Briggs, and through him, some experience with the court reform project that you're now in the middle of. So we get a lot of attention for being online, but one thing I like to highlight is that the online part can be really a distraction in some ways. The online part is why I get to go to conferences like these, but for me, it's secondary to our true mission. Our mission is, how do we take this justice system that belongs to people and build it around their lives? How do we acknowledge that people have a context, that they have a set of skills and abilities, but also limitations and challenges, that they live in particular places and time, and how do we take this justice system and accommodate all of that, instead of making them increasingly bend over backwards to fit into a brick and mortar justice system that was built for legal actors, but not for them. And at least in our courts now, we've reached a tipping point where most people in civil claims are self-represented, at least one party. And that's only going to increase. So technology is one way that we can build the justice system around the public, but it's not the only way. And so I'll also highlight the non-technology things that we do to try and build inclusivity, to make sure that nobody's falling through the cracks. And this is important because it's a cultural thing. And if you have that as part of your culture, it drives all of the technology and every other innovation that you create along the way. So like you, we have an access to justice problem in our jurisdiction, not just in British Columbia, but in Canada as well. And this seems true anywhere in the world that I travel. For us, though, our access to justice problem is exacerbated by the fact that we have concentrated urban centers and then very sprawling rural areas where access to courthouses, never mind legal services, is really difficult for people. So it's not unusual for people to be faced with having to take time off work, travel for days, sometimes staying in a hotel, just to access a courthouse. And then multiply that cost by the fact that they have to do that for every step they take in the life of their dispute, it becomes prohibitively complex and expensive. So we have access problems like you do, physical access, but also access created by complexity. And I should stop here to tell you a bit about what it is that we resolve, what kinds of disputes are within our jurisdiction, because I think that also has informed the development of the tribunal. So we were initially given jurisdiction over what we call strata disputes, which is just our funny word for condominium disputes. So shared ownership over a parcel of land apportioned in apartments, basically. These comprise a massive amount of residential housing in British Columbia. And until we opened our doors in 2016 for these claims, they had to go to our superior courts, which strata lawyers or condominium lawyers told us would cost their clients on average between $25,000 and $35,000 Canadian. That's about 20 pounds or so. It's very, the Canadian, that's my really bad Canadian currency joke, so I'll leave that to one side. Yeah, you guys have everything's expensive. Okay, so these are very expensive though. In Canadian dollars, that's a lot of money. Average household income is about $53,000 a year. So we had jurisdiction initially over these condominium disputes, which were kind of the orphans of the justice system because they had nowhere to go. Nobody in their right mind would take these kinds of neighbor disputes over pets and rentals to the superior court. But nevertheless, these little communities had festering disputes that just never got resolved and became a high pain point for people. Our other area of jurisdiction initially were small claims disputes, which are very similar to your small claims disputes. And we have jurisdiction currently over small claims $5,000 and under. So we started with these condominium disputes. We did those for about a year. And then we assumed jurisdiction over the small claims disputes last June. So we're coming up on a year of that jurisdiction. And then, because we can't rest on our laurels, the BC government 3 weeks ago now introduced legislation to give the Civil Resolution Tribunal jurisdiction over the vast majority of motor vehicle personal injury disputes as well. This, to give you some context, is sort of like walking and then running a marathon. It's a big leap forward, but we'll use the same implementation approach that we have successfully for these two other areas of dispute. I can tell you that the announcement that we'll have jurisdiction over now the wide majority of motor vehicle disputes has caused a lot of consternation among lawyers, particularly. I would say even opposition among lawyers. I think before this, while some lawyers were opposed to the tribunal, it was a bit of a difficult argument for them to make because small claims and condominium claims were not work lawyers were doing. Lawyers were not providing services in these areas for the most part because it just wasn't worthwhile financially. That is not true for motor vehicle personal injury cases in British Columbia. We have a full tort system and a contingency fee model where lawyers typically take between 33% and 40% of a motor vehicle settlement. So in other words, this is real money. And it's a significant change for our mainstream civil justice system. Okay, so back to the access to justice problem. The problem the government really wanted to tackle on a small scale initially with the CRT is this model where we create access barriers, time barriers, cost barriers, and at the end of the day, what we give people in exchange is a very one-size-fits-all solution. So we've oriented our entire civil justice system towards this idea that you will have your day in court. That if you file your papers and take your time off work and find parking and get to the court, figure out which desk to go to and queue up, that you will, some months or years later, appear before a judge. But we know from empirical evidence that that's not true about 98% of the time. And that stat is consistent in Canada, US district courts, Australia, and as far as I know, the UK as well. So in other words, for every 100 people who bother to file their paperwork, only 2 of them will get before a judge at some point. But that hasn't stopped us from orienting every single step we take in the life of somebody's civil dispute towards this idea that you will end up in front of that judge. And if we didn't do that, if we didn't make this assumption that you'd end up before a judge, then maybe we would think differently about what we ask people to do along the way. Would we ask them to frame their pleadings in an adversarial way up front? Would we ask them to provide us with mountains and mountains of evidence and exchange it up front? Would we have discoveries and interrogatories and whatever the equivalent terms are in your jurisdiction? I don't know if we would do that if we know that all of that work, or at least most of it, is useless 98% of the time. The other interesting thing that nascent research is showing us is that while lawyers like to tell ourselves that these cases settle on the courtroom steps and therefore the adversarial nature of our litigation system is useful because it incentivizes settlement, there is some research that suggests that about half of the cases that don't go to trial also do not settle. That they just go away because people give up. They go away by virtue of attrition, but not by virtue of resolution. So I spend some time on that because what I'm going to show you is how we're flipping that model and how we're trying to make sure that everything that we implement with the tribunal is based on evidence to the best of our abilities. And where we can't find evidence, and it's often hard to find in the justice system because there's a data paucity issue, we've had to either extrapolate from other fields or create our own evidence by commissioning surveys like this one. So this was in 2015, about a year before we started accepting cases. And we asked people through a landline survey what they wanted from their civil justice system. One thing they told us loud and clear is that they did not want a judge or a tribunal member like me making the decision. They wanted every opportunity to help craft a solution, ideally through negotiation or through mediation, and 87% of them did not want full legal representation, likely due to cost. The other thing this survey told us is that internet use in British Columbia was much more widespread than we had initially thought. So about 92% of people in BC in 2015 use the internet every day. And about 69% of people over the age of 74 are also using the internet every day in BC. Now, as far as I know, they're not hacking US elections or doing anything too radical online. What they seem to be doing are the kind of everyday things we all do. We're good at Googling things. We're good at buying stuff. We're good at emailing, texting, using social media, that kind of thing. And that was important for us because it allowed us to realize that if we design the technology to look like what people are already doing online, it's already going to reduce their anxiety level. It's going to increase their comfort level. And it was also a challenge to a question I got a lot, particularly from lawyers, about the digital divide. And the digital divide does exist, but it's rapidly closing. And it's not a complete answer to the question of why you shouldn't be bringing things online. And I'll tell you a bit more about our actual experience now that we're operational with providing online services. But we have had a huge take-up of online services. And so actually maybe I'll just cover that briefly now. Out of 6,000 cases that we've now accepted online, our default communication method is email. So people have to provide us with an email address or tell us that they don't use email, and then we'll accommodate them some other way. Out of these 6,000 cases, which by definition have at least one person or one entity on each side, we have had 6 requests not to use email, which we've accommodated. Similarly, we get maybe 5 paper forms a month, and we take in between 500 and 600 new disputes a month. So what that tells me is that even for people who don't love technology or are not terribly comfortable with technology, they would rather sit on their couch with their son or daughter or a friend or family member and an iPad and walk through an easy-to-use online application form than even go to the post office and mail something. Because we also accept service and provide service through mail, fax, telephone, and on government service counters across the province. The take-up on all of that has been next to zero. So one way to deal with the digital divide is to offer multiple channels for people to use, but I think this is strong evidence that the demand for online services is extremely high. And just briefly, about 81% of people said that they would use something like the CRT before it even existed, which was a pretty good vote of confidence at the time. So we took information from these surveys, but also a lot of information from real people. So I did a lot of town hall meetings where 200 or 300 random people would show up at a community center, and I'd talk about the CRT for an hour and take their questions. Susan made the point earlier that it's difficult to get a good base of the public interested in this stuff, and that's true. But we were in a bit of a different situation because these condominium owners were deeply invested in their condominiums, and they were very invested in the fact that there wasn't a good dispute resolution process. So that allowed us to have this captive audience of people who would show up on a Wednesday night. But that's not the only way we went about this. We also had focus groups. We do a ton of user testing. We user test everything that we develop. And we've developed a particular methodology for that makes sure that we're not missing anybody as we go. So I'll tell you about that too. All of this consultation and user testing and evidence, to the extent we could find it, led to these guiding principles. That if you're building a justice system around the public, you have to get people through it quickly because it's bad for their health. There's good data that shows that the longer somebody has a civil claim, the more negatively they perceive that it affects their financial, mental, and physical well-being. So getting people through the process quickly is important. Focusing on early resolution is important. Being flexible is important, letting people participate, empowering them to drive the process, which we do through using a variety of ADR tools, culminating in adjudication as the last step. We've also learned the hard way, though, that this flexibility applies to us as well. It's really easy to get cocky with a project like this and think that you know all the answers, and you have this idealistic way of doing things that you think will be utopian. And the antidote to that is rigorous user testing, because the public will not hesitate to slap you down if you get it wrong. And we had a few acute experiences like that early on that helped us realize this lesson and keep our ego in check. So we're constantly user testing, even now that we're operational, and we're never going to stop doing that. The CRT is open 24 hours a day, 7 days a week. Not surprisingly, but good to have data, about half of people who use the tribunal do so outside of typical court registry hours. People are primarily using the tribunal on weekday evenings, which makes sense when you think about when you get a moment to do online banking or go shop on Amazon for Joshua's book, for example. We're doing those things typically outside of business hours. Again, intuitive but helpful to have data. So we really try and build this around people's lives. We offer free legal information and support. Our goal is that you don't even have to come to the tribunal, and we do that through the kind of decision tree system that you heard talked about earlier. We also offer free telephone interpretation in over 200 languages, including several Indigenous languages, which is important in Canada. The cost is roughly what our court costs now in terms of user fees. But we did a big user fee survey, and we structured the costs in a way that people found preferable. People want to pay as they use services for the stages that they use, and so that's how we've structured our fees. We've also made it very easy to have fees waived if you're low income. And at least in our jurisdiction, that's something that courts are quite worried about. They think that this will be abused. If you don't make people run around and get a bunch of documents, and in our courts plead for indigency status is what it's called, which is incredibly difficult to do and quite onerous and frankly not very respectful of human dignity. They worry that if you don't have those barriers, that you're going to have massive abuse. Our system is just a basic online form. You click if you're on government benefits. If you're not on government benefits, you put in your household income. You click that that's true, and you hit enter, and you get your fees waived, and we don't ask you about it again. If it turns out your dispute is about a Lamborghini, we might ask for some more documentation. But beyond that, this has not been abused, and that was one of our theories that we're testing. I think it's helpful to show people that you can not compound people's barriers to accessing justice. You can make it very easy for them to enter and navigate the system. You don't need to be worried that you're going to have rampant abuse. Last but not least, we focus on active case management. We tailor the timelines. I'm going to torment you by showing you a form later that I'm really proud of, but the form is developed by users. So we co-designed it with the public. And that's important because half of all adult Canadians with a post-secondary education cannot correctly fill out a government form. You heard Susan talk earlier about 40% of the forms being bounced for divorces. That's about what we're looking at. And that not only chews up a lot of staff time, but it really frustrates people. So we have simple forms, we ask for information once, and then we carry it through. But more importantly, we design the forms with people so that we know they can use it. This is basically how this thing works. At the front end, we have something called the Solution Explorer, which is the decision tree you heard debated earlier. It's a very basic form of artificial intelligence, and I'll show you what that looks like. It's free, it's anonymous, you don't have to have a CRT claim. In fact, we want you to use it before you file a claim. We insist you use it before you file a claim. So it may be a bit paternalistic, but we make people spend about 10 minutes going through this question and answer system first before they can file with us. The next stage is negotiation. That's a very basic, almost chat room feature. It allows people to start talking in a neutral virtual space. Doesn't resolve a ton of disputes, but kind of skims off about 10%. That's another 10% we don't have to deal with. If people reach an agreement in the negotiation phase, we can have that sent to a tribunal member and it's turned into a tribunal order. Tribunal orders are enforceable court orders, so people get certainty there. The third stage is facilitation, which is just our word for mediation. That's where one of our expert mediators, who is not a judge and often not a lawyer, but an expert mediator, works with the parties through whatever communication channel they choose, whatever method they want, to help them reach an agreement, which again is turned into a tribunal order. Last but not least, we have adjudication, the least innovative part of all of this. The only thing really that makes it innovative is that it's all done electronically. So evidence and submissions go to the tribunal member electronically. The member writes their decision and that's emailed to the parties if that's what they've chosen as their communication method. The other small innovation is that we really try and make it plain language. And so I put all of our tribunal members through a boot camp where they have to unlearn 20 to 30 years of legal practice and education and start talking like normal people again and writing like normal people. And there does need to be a correlation between the longer somebody has practiced and the harder they find that task. But it is a hard task and it's not the way we're oriented as lawyers. But what you can see at the bottom there is that the case volumes decrease as you go along the process, while the resources in time and money increase as you go along the process. So the goal is flipping the traditional model. We do not assume everybody's going to go to adjudication. In fact, quite the opposite. We assume that if we give you the right help and support early on, 90 to 95% of the time you're going to be able to solve your problem without getting before a tribunal member. So that free portal at the front end, almost 20,000 people have gone through the one for condominium claims, and another 20,000 people have gone through the one for small claims. And the number of people who have actually filed claims is much, much less. Again, a total of about 5,000 to 6,000 people on a rolling basis annually. And it gets smaller and smaller as you go. So this is what our website looks like. The tagline here is, what can the CRT do for you? And we get told a lot this doesn't look like a typical court or tribunal website, which I always take as a compliment, with all due respect to anybody who runs court or tribunal websites here. But we wanted it to look fundamentally different. We wanted it to look friendly, easy to use. Everything we write, from the web content to the Solution Explorer, even to our decisions, we aim for about a grade 6 reading level, which evidence tells us is about the general reading level of our population. The other quick thing I'll say about this is it uses responsive design, which just means that if you Google something on your phone, it looks like that as opposed to a giant website shrunk down into size 2 font. We also don't make people download any legal apps because those themselves create a lot of barriers. You should just be able to Google Small Claims BC and get that and be on your way. The other important thing about this is that advocates tell us that their clients are very unlikely to have a desktop computer like that, or a tablet even, or a laptop, but they will almost certainly have a smartphone and know where to access a data hotspot. So if you're developing technology for everybody, it has to use responsive design. It has to work best on a smartphone. So the Solution Explorer, that thing we make everybody go through, is on the top right-hand corner, but there's also content driving people to that throughout the website. So at the top-hand corner, people can pick their issue type, strata or small claims, and I'm going to walk you through a really truncated version of what this looks like. So the idea here is that instead of giving somebody 10 pages on creditor or debtor remedies if they have a payday loan, that you can actually give them pretty granular information if you ask them questions first. Because people don't often see their issue even as a legal problem, it's just a problem for them. And so 10 or 15 pages of general law isn't so helpful. But we use kind of a funnel approach that you might see in a lawyer's office. You start out broad, and then you ask more granular questions until you get to the point where you can give them concrete legal information and tools. And then we test, and we ask for feedback along the way. So the most common small claim type we have is loans and debts, often payday loans, so very small amounts. So I'm really skipping through a lot here. If you think there are steps missing, you're right. But just to give you a flavor for how this looks. People pick their dispute type, and then we start asking them questions. So what best describes your issue? Is it that you can't pay what you owe, you only owe some of it, you have already filed for bankruptcy, and so on. And this comes from interviewing volunteer lawyers and sitting down with them and asking them what the most common issue types are What do you wish people knew who came into your office? Are there deadlines they should know? What are their options? And if somebody's issue is not here, they can click that button underneath, or that hyperlink, which you can't see because it's very small right now, and they can tell us what's missing and send us an email, and then we can help them. But that feedback we call the treasure trove, because on a rolling basis we're looking at all of that feedback, and it tells us where to build out this highly vascularized mind map in the future based on public feedback. We also have a progress bar. People like to know where they are. And as we show people resources, they stack up on the left-hand side. So we ask questions, and then we give them plain language bits of legal information. People can rate this. There's those 5 stars at the top there, as well as that angry red not helpful button, which is very cathartic to push. I've pushed it myself sometimes. And so we take all of that feedback too, and if a resource like this is getting half a star or 1 star, we know we need to pull it and look at it. We refresh all of this content every 3 months. So every 3 months it's taken off and a new version is uploaded based on public feedback. So yeah, questions, legal information, and then once we've given people enough legal information, we can talk to them about what their options are, their self-help options. Would you like to suggest a payment plan? Do you want to speak to a trustee? Do you want to file a claim? So this person has decided to suggest a payment plan. But first we need to know how much they can afford to repay, so we give them a tool to help them calculate that. And then this leads to the most popular resource in the Solution Explorer. These are pre-written template letters that already have the relevant statutory provisions, deadlines that are applicable. All the person has to do is enter their own data, their name and telephone number, address, and then print it, email it, or download it. But they can do this from a public library. They don't need Microsoft Word or anything else. And again, research suggests that people are really intimidated by writing demand letters and that kind of thing. So a very popular tool. At the end, people go to a summary page. At this point, we hope they'll send the letter. We hope never to see them again because their problem is resolved. But if they have to file a claim with us, they can do it seamlessly from this page. And that takes them to our online application form, which we test first with advocates. So the way we develop this is we identified a group of legal advocates who represent people with barriers. Ideally, you'd want to do the testing with the clients themselves, but on Maslow's hierarchy of needs, testing our small claims form doesn't really rank very highly. And so we test with the advocates as a good proxy for that. These are people who use systems a lot and know what their clients can and cannot do. So we test with the advocates, we make a bunch of changes, then we recruit random members of the public. We ask them to fill out the forms in exchange for a small gift card, and then we interview them, and then we make a bunch more changes. And then we test with the lawyers. So we test with the most vulnerable folks first, not the loudest folks. The loudest folks are the lawyers, and we get to them, but we get to them last. And the reason for that is because if it works for advocates and their clients, it will almost certainly work for lawyers. And that's held true. We also ask people along the way if there's things that we can do to make their experience better, to accommodate special needs they might have. And this is optional information, but it identifies, or allows people to identify if they have literacy issues or visual or hearing impairments or other circumstances that would make it hard for them to access the CRT. And by extension, difficult to access the court system too, I might add. So, for example, if somebody indicates they have a visual impairment, one of our staff members will call that person and ask them what supports they have in place and what we can do to make it easier for them, which is often something very simple. For somebody with a visual impairment, it might mean having a telephone mediation instead of relying on emails back and forth, or having an oral hearing as opposed to a hearing on the written record. Okay, so once people have filled out the forms and exchanged documents, they've served the other party and the other party has come back in, they have an opportunity to negotiate in this virtual kind of chat room, which is designed to look very much like texting or Facebook Messenger, stuff people are already familiar with. And about 10% of the time, people can work out an agreement. And at this stage, as with the Solution Explorer, there's been no human interaction really with the tribunal aside from staff members screening the intake form. If the negotiation is unsuccessful, which most of the time is not successful, a mediator steps in, again, working with people's preferences. So if somebody prefers to engage in the evenings after their kids are in bed, that's fine. If they'd rather have a telephone mediation, that's fine. Last but not least is adjudication. We have 38 part-time members, 5 full-time members, all experienced lawyers located around the province. With our new personal injury jurisdiction, I expect this will actually increase to 65 full-time members. which should tell you something about the scale of the number of cases we're expecting to come in next year. Our hearings are mostly written hearings. We do have the capacity to do oral hearings, which we do from time to time, but these are on people's smartphones, for example. And our decisions are published on our website using a really rigorous database, which should be comforting to those of you who do empirical research in the room. You can search for Salter and condominium disputes in a particular type and see if there's any correlation with the way people decide certain cases, which I think is important in terms of transparency. Our decisions are also published on Canley, which is our version of Bailey. So I talked about, just to wrap up, inclusivity as a core value. A lot of the things you see here that we do to build a more inclusive system are not tech-based. And they come from talking to community advocates and asking them what would make their clients feel more respected and treated more fairly throughout the process. And what they told us was pretty heartbreakingly simple. And so we've implemented almost all of them. They're not big ticket items. They're things like, can you make sure your staff have training in mental health issues? Can you make sure your staff are culturally competent? Can you make it a welcoming place for helpers? Can you use plain language? Can you involve us in testing? Can you give us a phone line where we can skip over everybody else and talk to a human if one of our clients is falling through the cracks? So we do all of those things, and I think they are important and they drive all of the technology that we develop as well. Oops. I'll just end with this. I know I'm running out of time. We survey people who have gone through the process. We now do this on a rolling basis. Monthly, we report out on it. These stats are a bit aged now, but the numbers are pretty consistent. We get really strong numbers on things like CRT staff and members treating us fairly, on the process being easy to understand and the forms being easy to use. And about 80% of people who have been through the process say that they would recommend it to other people, which is a pretty strong endorsement. Skip over that. And I think I can talk about this later in the question period. This is just where we're going. So one of the things that we're really looking at is how do we use data and analytics now to drive our processes forward? We've already started to do that, and I'm happy to talk with you more about it. I know there's some researchers in the room. We also try and publish our data as much as possible, and if you're interested, we will be publishing an annual report in the next couple of months, which will be pretty data heavy. So with that, thank you very much. Oh, I'll just put up my contact information if anybody wants it.
Thank you so much, Shannon. That was brilliant and really interesting. I think because I'm conscious I'm not quite as good at chairing as Hazel, we will whip straight forward to Dory, who's going to make a presentation now.
This is, I've had a great difficulty deciding what I was going to leave out. But let me start, like Richard, with a little bit of an anecdote. I was advertised here as a judge in the Amsterdam District Court. I retired about 2 weeks ago. And again, that was some interesting lessons happened there, because I had my farewell reception in one of the in the IT building of the Netherlands Judiciary at the end of April. And what happened there was that all of a sudden it struck me that this is a closed building. So no one who had heard of my farewell reception could just come up and get into the building, because you have to be announced before as a visitor, and if you're not a registered visitor, you will not come in. So that's one thing. And then the next thing, that happened to me when 2 weeks ago I went and gave my smart card back to the organization, because I'm no longer employed by them. So I went there and I had an appointment with a security officer to give back my card in the building, and I walked up to the pole that's there where you hold your card, and it went red. It denied me access. So I went to the receptionist and I said, I'm here to bring that thing back and I have an appointment, and he said, oh, I can do that. And do you have anything else you have to give in? And I said, well, no, not really. So here's my card. And then I realized that we have these high-level theoretical discussions about access to justice among people who are so used to having their sphere closed off almost all the time. So I was thinking that may not be the right mindset to talk about this subject. So just a thought to start with. So my latest claim to fame is that I built the digital procedure for the civil commercial claims in the Netherlands. It's up and running. We're rolling it out by the end of the year. If you're interested, I can tell you more about that. But that is not what my talk is about, because I have understood my role for today as explaining to you what is happening in justice in continental Europe. And now that I'm retired, I'm in a wonderful position to actually talk to you about that. I moderated the network meeting of the European Network of Judicial Councils 2 weeks ago on going digital. So I heard what the debate was there. Last week I was in Bologna in Italy for a conference with researchers from Europe and from Canada about their research program into access to justice and court IT and all that kind of thing. So a little bit about a few tidbits from those debates that are going on in continental Europe. So let's see where we go. What happens if I do this? Yeah, one thing about going digital is that we all talk about IT is going to make life more efficient and cheaper, and we're going to enhance the quality, but actually the down-to-earth reason why courts are going digital is just because everybody else is. So digital is the new normal. And what I would like to talk to you about is what do we actually talk about when we talk about IT? I found out that people talk about very different things without specifying what they mean. So there's a little bit about that. Then I'll talk about court IT in Europe. One of my favorite subjects is court IT is difficult, and why is that? And how can we actually, let's say, reflect on what makes it difficult? What can we do about it? And then my final question is, what justice are we talking about? So this is a map of Europe. It comes from the evaluation report by the European Commission on the Efficiency of Justice. And this is about the best information we have on the state of court IT in Europe. And it's not great, it's not even good, but it's what we have. So we have to be very careful using it, because not all of the information is good enough to use. The methodology is that this report came out in 2016 in October, and it consists of data that were collected in 2014. So by now they've collected another set of data. Presumably there will be an update of the report in October of this year. What can we learn from this? Everybody by now has office technology. So 100% of the courts in Europe have office technology. I'm very interested to see what digital communication courts have, because I've found over the years that was, let's say, the edge at which the courts were pushing. How far can we make digital communication work? And 74% of the courts' systems now say they communicate digitally with lawyers. Now, that can be just lawyers sending emails to the court. It can be certified email. Some use websites, so it can be all sorts of things. That 70% is not just the communication, it's also filing for lawyers. And that can also be done. Some do it by email. My system would never do that, because they don't think email is a secure way of communicating, because you don't know if it comes from a Hotmail address what it is. What I'm most interested in, and I always have been, is digital filing for other people, because that's where the access issue comes in. Part of my dissertation is on access to justice, so this is where I always look, and I've learned a lot from Hazel's research about what to look for. But so far, I think we must say that digital filing for other people than lawyers is still experimental in Europe. And that has to do with security issues. It has to do with secure ways of identifying yourself. I can use my digital identity for the Dutch government to file my taxes, but to access an adversarial procedure that also involves personal information from somebody else still is a no-no in the Netherlands. And I think for most continental European systems as well, except for countries like Estonia and Lithuania, who have a secure government service, and the your justice system operates within the government service, and that is secure enough. The trends we see across Europe is that there are fewer courts. There is a concentration of court buildings like it is here. There's more technology, and the technology is also used more for using quality indicators to see how well the courts are working. Now, this is a little bit about the report. I don't want to spend too much time on that. Though the last thing I would like to mention is on this page is the Consultative Council of European Judges. That's an advisory body to the Council of Europe. They produced an opinion in 2011 on court IT, and it was my privilege to be their expert. So I am really proud of what opinion 14 says. Somebody said to me last week that it is a document that will last for a long time, and I was quite relieved when I heard that. So, I've seen the warning, thank you. Why do projects fail? There are a lot of reasons why projects fail. But one of the expert opinion is that executives, the people at the top, find it difficult to imagine what IT actually does for companies, and that includes court systems. It's very difficult to imagine that. And so there are usually, for the executives, there are some surprises in store. How does it affect judiciaries? We have found out now that we're rolling out this new procedure, how it's going to affect us. And the only way to find out is to do it, and to just jump in and then figure out what you find. And the last point, the difficulty for the leadership to figure out what it has to do to make IT initiatives succeed. Now, I'm sure some of you will recognize that. The development that we're seeing now is not something that is absolutely new. Andrew McAfee wrote about it in 2006, and that is the difference, and I think it's important to keep that in mind. Network technology is where you have a paper process, basically. Your primary process is paper, and you have tools that you use. You use word processing, maybe you use calculation tools, whatever, and you take them and use them, and then it's like you're putting a tool back in the closet. As soon as your primary process, that is the process which produces your actual core product, goes digital, it imposes a new work process on everybody involved. And there is no work left outside of this digital process. Now that is a dramatic change, and it means that your entire organization needs to be rethought on how they work together, who decides what, and you must also keep in mind that as soon as the new systems go live, we must have those things in place. So I'll skip this one. That's enough, I would say, depression for now. Something else that we have found when we were implementing digital systems is how difficult legal culture can make it. Now, you are lawyers, I'm a lawyer. What happens when something goes wrong? We look around us and we find someone to blame, don't we? Now, that attitude is counterproductive to innovation. Innovation means you tried something and it doesn't work, and then you try something else, and you keep working like Shannon has until it works. And then if your surroundings keep saying, "Oh, but it's your fault," and that really doesn't work. So that judicial organizations and probably lawyers' offices have to learn that being innovative means that you have to abandon the idea that someone is to blame when something goes wrong. I'm nearly there. No, I'm not, but there's stuff going on in the European Union. I don't know if I bother you with that at the moment. I'm sure you found the portal. There is the European Case Law Identifier, which is a unique identifier for all case law. There are European procedures that are not used all that much. This is the portal with information for people who need to do cross-border stuff. And this is the Slovenian announcement that they had introduced the ECLI. And I use this one because Slovenia was actually the first one to implement the ECLI, but it was invented in the Netherlands, and we, I think, were number 2. What happens, you have an ECLI, you see it on the screen there, it's that long number. If you click on that, this is a Dutch decision, this is the EU Justice Portal. If you click on the number, you get to the Dutch judiciary website, and there is the full decision. So this is how, across Europe, judges can find each other's jurisprudence, can learn from it. This is unfortunately a decision that was published only in Dutch. And these are the conditions. So this is my last slide. And what justice are we actually talking about? I don't know about you, but we have found that caseloads are going down, which means that the courts have less of an impact in society because of it. There's a lot of privatization, there are a lot of alternatives, and I also used to think that things that can be resolved somewhere else, great. So let's reserve for the judiciary only the complex matters that they have to deal with. But I now see that in my judiciary, the minds about that are changing, because if you do that, all you have left is just the little bit of the complex litigation. And as a society, as an institution in society, that is going to make you less significant. So we really want to think if that is the kind of justice that we want. We think justice should not be left to the market, because that impacts the credibility of the justice sector as a whole.
Thank you so much. That's great. And now, without further ado, Professor Chutkow.
All right. Well, I'm gonna take a little segue back from the broader issues about what is justice and how courts are operating, and give you a little bit of an insight from the scholarly perspective and from the empirical research perspective, hopefully with a bit of an argument for the kind of partnership that can be engaged in between this very new and forward-thinking program that's going on in the UK and the kinds of things that empirical scholars might be able to bring to the table with respect to that. I'm going to do that from my catbird seat as an editor for the Journal of Empirical Legal Studies, which the acronym is JELS. For those of you who are not in academics, this is a journal that is dedicated to articles that use data, and then take that data and use sophisticated and sometimes straightforward statistical methods and address those to questions that might arise within the court systems, justice systems, and other legal systems. So JELS was started in 2004 in the United States in response to a growing need and interest in these kinds of studies. And I just want to show you that in fact, this is synergistic with the kind of technological advancements that is making this project and this program possible. So when you see increasing numbers of scholars engaged in this sort of research, you also know that you have increasing number of scholars and increasing number of resources that can begin to analyze how these programs are working, in particular programs like this that talk about bringing the legal system online. So this is just a quick proxy from our journal for the kind of downloads of empirical legal studies across various countries. This is non-US. The y-axis is missing because it's a combination of individualized downloads and institutional access, but it's in the tens of thousands. And I'd like to just highlight for you in particular the UK. So everyone is trending upwards in this, but this is a very good proxy, and as many of you in the room already know, that you have the talent, the research, and the training to be able to use to analyze the kinds of programs that you're engaged in. So from that perspective, let me talk a little bit about what's going to be first and foremost for most of those in this room who do empirical legal scholarship. The minute you hear about this program and Susan's presentation was data and the availability of data and what can be done with it. So I'm simply going to suggest that there is a wonderful opportunity to use legal scholars to crowdsource for problems that you may think are there, and problems that maybe you don't necessarily know are there. Sometimes having outside access and outside eyes know how to sometimes gives you a perspective that's extremely helpful. I'm just going to give you a little bit of an outline on how this might work, and then some examples of the kind of research that we're seeing throughout the world with respect to empirical legal studies and systems. And it's research that it spans a vast range of topics, from whether or not family groups navigate the Chinese property dispute system better than non-family groups, to the kinds of studies that have been done in the United States, not so a concern in the UK, about the death penalty and whether or not that's being implicates sort of disproportionate application. Which, by the way, these sorts of things can be highly informative to the judiciary. We had a recent decision in 2015 on the death penalty in the United States, in which 3 separate articles from the Journal of Empirical Legal Studies were cited expressly within the course of the opinion. So judges and justices are using this sort of information as a way to inform themselves. So not only that, but also how systems work. So raw data, court decisions, opinions, and dockets data are very helpful. They've been around for a very long time. They drive sort of the more theoretical components and descriptive components of this kind of research. But I saw Susan's slide with a great deal of interest of the papers stacked up on the back of the radiators. And the fact of the matter is that that doesn't help get us to be able to analyze what's going on within a court system. It's very difficult. And even putting all of that in text and PDF formats onto the web doesn't really help as much, because it's not analyzed data and it's not coded data. So what really is very, very helpful is to have some kind of coded data with respect to these matters. There you go. Coded data. 78% of the articles that we see published, and I think most empiricists will tell you this, come from pre-existing data sets. I mean, I tell my students always it's very important to create a data set yourself once, but really that's probably the only time you're going to want to do that. It's a lot of work. It's a lot of energy. And as a practical matter, when you see the data coming in piece by piece, as in the case when you put court dispute resolution online and people have to click through, every click is a data point that can be captured, saved, and used to analyze how the system is operating. And that's far easier to have that done at the intake end than to try to jerry-rig it and create it at the back end. So that's one broad sort of wish list of the number of wish lists I'm going to offer today in talking to you. So coded data is extremely important. And it'll tell you things that you might not even know are problems. So this is a very famous article that we published in 2004 on the US courts. And what it shows you is civil trials and this precipitous decrease in civil trials, which was happening with a companionate increase in civil case filings, which seems to be a bit of a puzzle. But the fact of the matter was that what people were doing is settling, right? This hydraulic pressure to settle outside of, and of course, all of you who are engaged with the system know this, ADR, mediation, settlement. But it's really important for you to know with those civil case filings and that settlement activity whether or not, as Shannon noted, whether or not the abandoned cases and the abandoned filings are a function of people just giving up because they don't have access, or is it a function of attorneys basically making demand letters? Our National Center for State Courts did similar studies like this, and a lot of attorneys will tell you that's the first move when you make a demand in a settlement, is you make your filing. And then you just abandon it because you've scared the other side sufficiently. This has implications, obviously, for access to justice and disparities of power in terms of who's capable of doing that and who isn't, which this program could address directly. So coded data and having those data clicks available in some way for researchers is extremely important in understanding how the system is working and whether or not it's working in the way that you might anticipate. Hard to know when you're doing it, whether or not what the outcomes might look like. So a couple of notes on that as well that helps with respect to this sort of analytic research that can be a partnership. And that is the need for cradle-to-grave data. as most researchers who do this work understand, there are huge selection effects in data as it moves up through the system, as a function of also of this settlement movement out. But the cases that you're looking at the very top are just a minute representation of the actual disputes that come through the system. And if you don't understand what's happening at each stage of the process, you don't really understand what you have at the end. So I was just delighted to hear about the fact that you're going to have incoming data about who is actually filing a dispute, and then you can track that systematically all the way up the line. One of the sort of confounders in the U.S. is that we often have data at the trial level and data at the appeals level and then data at the high court level, but they are never compiled in one continuous system. It's very difficult to track from one to the other. We have scholars who try to do it, but it's very hard. And the other aspect I'd like to talk about a little bit is the systematic collection of data, the importance of making sure that you understand what you're asking for when you're doing those data clicks. I'm just going to give a shout out for demographic data here. I was really surprised to hear that you're not collecting that. I will tell you that any paper that comes into my journal that doesn't have a control for demographics is going to be kind of moved over to the side. It's an important component part of the litigation system because it proxies for a lot of other things. And because you may have differential satisfaction based on your interaction with the justice system that may also be proxied based upon demographic data. Men and women often react differently to different inputs. It's very hard, I think, to adequately understand what's going on if you don't have that information. And then also, of course, a shout out to having that kind of information available. And open to the public. So, Shannon, I know you mentioned that you can just click on and get access to, some of it. But those underlying databases, those underlying pieces of information, that big complex spreadsheet, to be able to access that as a researcher is really vital. And we see across the globe in terms of the kind of research that is doing the most innovative and insightful sort of research, it's the scholars who are able to get hold of that kind of data that are able to do this sort of work. So let me give you just a couple of examples. Some of it will be relevant to the particular process and how this program may or may not be functioning, and some of it will give you an idea for not only the near future, the mid future, but maybe way down the line as to where this kind of information can be used in a positive way. So there are I'm going to give you in tranches: civil system incentives, criminal justice outcomes, social responses, and then sort of the trending, what we see is sort of the trending kind of research in this particular area. So in the civil justice system incentives, this is an enormous question, and there was a question asked from the audience last session about, what's going to happen when you open up access? Are you in fact going to have a lot of people coming in that are putting in meritless or maybe frivolous cases, or are you actually going to get cases that should be in the system? And is there a value to having barriers to entry that people have to sort of calculate the economic cost of what does it mean to have to go to court, as opposed to getting angry and pushing a button? That's a really relevant thing to ask. You can track that if you allow these sort of data clicks to be able to put who is coming in, what are they doing, under what kind of claims are they making, and we've seen sort of really interesting papers done on sort of who's succeeding within the justice system, who's managing to make it up to appeal, what do those cases specifically look like. Representation is a really important component of it. I'm hearing here that it's very similar to what we're seeing in the United States, that self-represented litigants are becoming an enormous component of the civil system. It's shocking how large it is, and even at the appellate level, both at the state and federal level. So who's doing that? What are they asking for? Is this something that can be handled? Is this good for the courts on the front end in terms of the number of the influx, or isn't it? Questions about whether or not changes in legal rules might be able to impact who's coming into the system and how. So we had a recent case in the Supreme Court in which it made it easier for defendants to push plaintiffs out of court because if they had relatively weak cases. And the big question was, is that actually actually working? Are people actually pushing plaintiffs out of court who have weak cases, or are we getting litigant behavior changes at the front end? Enormous number of empirical studies looking at that. And other things, out of Canada, for example, there was a very interesting study done with respect to changes in jurisdictional limits for small claims court, and whether or not that has an impact. Now, this has direct applicability to opening up the doors and what that looks like when you do so. And obviously, damage patterns are something that's looked at very often in the United States. But it's not just civil justice incentives. It's also criminal justice incentives that you can take a look at. Things about sentencing, for example. Is it uniformly applied across various groups? Sentencing guidelines, minimums and suggested sentencing guidelines. How are those operating within the context of the system? We see a lot of research on that when we have access to the underlying data with respect to it. Whether or not, very simple sort of administrative matters as to whether or not the form that you have to fill out for judges to calculate a sentencing guideline, if it's formatted in one way, do you get fewer mistakes than if it's formatted in another way? Empirical studies have taken close looks at that. And then very quickly, sort of social responses. We've seen a lot of research, particularly in the US, about liability limits, damages, and what that does in terms of doctor behavior out in the real world. So this is sort of next stages as to where this kind of data can lead you. Do doctors order more cesarean sections, more tests for cardiac patients? Are they scared when there are no limits on liability versus when there are limits with liability? Really salient social issues that are beyond just court functioning. So finally, I'm going to close up by talking about where the trends are going here. The trend is big data and predictive modeling. So this is largely here, but it's coming even further down the line as well. Questions about risk assessments in bail. Do you allow someone out pending trial, and what kind of characteristics might make them more likely to be violent when they're let out? And the court system input data on a criminal justice side can be used to analyze that. Whether or not in domestic violence settlements is someone more likely to recidivate based on certain characteristics. Now that's kind of new world scary in some respects, but this is happening. And so if you allow large numbers of researchers to analyze it, to look at the underlying algorithms and the assumptions that are behind it, and be able to figure out whether or not those assumptions are valid and fair, if I can use a word that my law professors used to tell me not to use, valid and fair, that's a really important component part in understanding how your system is operating. So to that point, I would simply say that much of what the scholars in the room who do this kind of research are hearing is absolutely wonderful, and I will make a plea that those of you who are in control of that sort of information allow it to be accessible and freely used, because there can be a really vital partnership in terms of making the system work the way you want it to work, and asking the kind of questions that you need to have asked.
Thank you so much, Dawn. That was really, really interesting. And I guess one question that sort of all three presentations raised for me is that given the sort of primacy that all of these systems seem to place on settlement and negotiated settlement, whether the IT systems should be putting in process, or if it's possible to put in process, procedures for monitoring outcomes and settlement levels to check that, you're not creating a system where you're resulting in people settling for things that aren't in accordance with the law as it stands. So I guess, is there any potential to develop a sort of rule of law framework for evaluating these processes? Does anyone from the floor have any questions? Yes, Lisa. If you could say who you are, that would be great.
Burkhard Hess, Max Planck Institute for Procedural Law in Luxembourg. I have a question for all speakers. Shannon, when you explained tribunal, I had the impression it is a little bit different from what we do now in Europe on the continent. It was for me a kind of combination of help for litigants or for consumers. So what you are doing there is a kind, from my European perspective, giving advice and assistance to consumer to solve a dispute. Was this a little bit the focus?
Yeah, I think for us it was about creating a neutral front end that didn't involve staff members giving legal advice, for example, that would go just as far as we can with providing legal information, but not legal advice, acknowledging that that could be a gray line. Where we're in doubt, we push it a little further, because the reality is that people just can't afford lawyers. And in the old system, maybe in the 50s or the 40s, somebody at the front end of their claim would sit down with the lawyer would give them a straight evaluation and tell them what the risks and benefits are of going forward with a court or tribunal process. People aren't doing that now. And so often the first time that they understand the strength of their claim is when they're well into it, either in terms of time or money or both. So one of the ways that we also try and even the playing field between sophisticated corporate parties which have access to legal information and people who don't is to give everybody as much as we can at the front end. But I don't think it was a conscious decision to be sort of more European. It was more about how do we level the playing field? How do we empower people with conflict resolution tools? Some of our tools are things like a video on how to have a difficult conversation, which as a society we've lost, right? We don't know how to talk to our neighbors and ask them to turn down the music. But if we can empower people to resolve their own conflicts, that also reduces our caseload going forward. And even if people do come to us, they come to us in a more realistic state, where they're taking more realistic positions, settlement positions, and they have a better understanding of what's likely to happen. Yeah.
Jim.
Yes, I'm Jim Greiner from Harvard Law School. Shannon, this question is also for you. You mentioned that something that resonated with me, that the longer that someone has been in practice, or perhaps even alive in the law, the harder it is to write materials that are straightforward and accessible to normal human beings.
I stand by that.
It's been my experience as well. We've encountered it in my lab with writing self-help materials. And I'm wondering whether you've ever had any experiments that you've done, or any, I should say, any effort to try to involve law students.
Yes, thank you. Yes.
Those have been our best creators of self-help materials, because they can understand the law, but they're still normal human beings mostly.
There's a nice Venn diagram there. Yes, I agree. And we have a couple of really exciting law school courses that are being headed up by Darren Thompson, who's a real leader in this area in British Columbia, as well as Lauren Kerr. And one of, I can tell you more about some of those, but one of the things that we've done is have an externship program with one of the university law schools, where law students are the knowledge engineers that help create content for the Solution Explorer, that guided pathway question and answer system. And it's precisely for that reason. They're interested, they understand it, they're the conduit between the volunteer lawyer who gives them the information, and then they create the content in language and in an intuitive way that normal people can understand. And they have, the content that they have created has in some cases been head and shoulders above the lawyer consultants that we've used in the past for that, and so we're going to expand that project. Happy to talk with you more about those programs and how, and sorry, just one quick thing I'll say about that is, as a prof too, I know how it's really resonated with them to be able to create content that people are actually using, because we know as profs that their exams and papers end up in the recycling bin after an appropriate period of time. But this is content that other people can really use, and they found that very gratifying. It's really a win-win situation.
Hi, Alex.
So I'm Stella from Reiling University. Another question for Sharon. I was very curious to learn that most of the users actually access the process through mobile devices. And we do have some research from behavioral economists and decision makers about the kind of decision-making process that users have when they access it through a computer versus a mobile device. So for example, some UCL economists have shown that financial decision-making is a lot less thorough and even possible when it's done on mobile screen as opposed to the computer screen. So the same people are not able to answer the same financial questions on a mobile device compared to a computer screen. So I'm wondering what kind of checks, or whether you all have any comparative research on the results that people are getting when they access the procedure through a computer versus a mobile device, and whether in your design processing you're trying to implement any strategies to help people go through a more thorough decision-making process on mobile and more sort of reckless device.
Yeah, I should back up and say it's not the case that more people are using mobile devices. It is the case, though, that almost everyone has one.
Okay.
And so you need to make and especially low-income folks. So I don't have good data on mobile versus laptop. I think it's about 50-50, but don't quote me on that. And no, we haven't looked at it at that granular level. What we've done is try to make sure that everything is very simple and paint by numbers. But it would be interesting to see if you can extrapolate from financial decision making to settlement offers or other decisions people have to make through our.
Do you have the data recorded? So what kind of device was used to access?
We do. I just haven't looked at it for a while. So we use that through Google Analytics, because all of our cases have to come in through our website, so we can tell what device people are using when they come into our website, which is the portal for everything else. But I can maybe follow up with you.
Part of the data that is available on your.
No, and I don't want to oversell that. We are going to make more and more of our data available. I can pull up a dashboard right now that shows me exactly what kind of case types I have in a pie chart, how many have come in today, what we're doing with them, what stage they're in. And we're trying to make that as public as possible. So where that is now is I do blog posts about it and tweet our stats monthly as well as our participant satisfaction rates. But it will be rolled up into more monthly reporting and annual reports. That's my goal. So please follow up with me if you're interested.
I will. Thank you.
May I ask one additional question? Dory, you talked with Wright about the situation on the continent and the different initiatives of the Council of Europe and the European Commission. Do you see, let's say, a role of the Commission when it comes to the digitalization of justice, which transgresses a little bit the role of member states? And if I may add one additional question to Professor Chutkow, the problem with data is very often that you have to understand the background. And we are dealing very often with data coming from different jurisdictions. And my question would be, what is the role of comparative law when it comes to big data which come from different jurisdictions or countries, even cultures? This is a huge problem also within the CP and with the judicial scoreboard of the Commission.
Your first question, is there a role for the European Commission?
How do you see it?
How do I see it? Oh yeah. Well, let's say the European Commission thinks it has a role, and it has shown what that role can be. They have devised European procedures for cross-border litigation. And you know, one thing is that what we see happening is that a little competition among dispute resolution mechanisms may actually raise the quality. So I think the European Commission could play a role there, but then the quality of the procedures that they have devised should be much, much better than they are now. I don't think that for the small claims procedure or for the European order of payment, they have not done user testing at all. And the experience is that the European order of payment works well in countries like Germany and Austria that have a payment procedure, and in the other countries it does not, because there is no follow-up. So yes, competition, but they have to step up the quality. Yeah, and I'll leave the comparative law question to Dawn.
All right, well, I'll answer this very
Something
quickly.
to say about that.
Yes, it is complicated. There are a couple of answers to that. This happens, there's a lot of comparative law research being done. Some of it is at the EU level or at the aggregated level, so the European Court of Justice, there's been a fair amount done about that. With respect to different jurisdictions within and comparing, it depends on whether you can get apples to apples in terms of your comparisons. And it depends on the questions you're asking. But statistical methodology allows you to control for a lot. And if you model carefully, there are ways to ask those questions and do it across multiple countries. And there's a very robust comparative, I'm sure from Max Planck you know this, there's a fairly robust literature comparing systems across different jurisdictions. We have the same problem in the States with the different states that have different legal regimes.
Right, so Judge Knowles, Professor Genn, and then Professor Resnick, if that's okay. So Hazel saying she's fine, so Judge Knowles, please.
For Shannon, I think. Shannon, is it, how possible is it to assist people with the use of technology and yet not assist them with advice in the underlying legal problem? Is that a realistic?
Can you give me an example of of what you mean by that?
May I make a small intervention? I was going to do an advertisement for Shannon's system and say you can try the Solution Explorer yourself. And I have done it, and I think it's extremely useful because then you experience how it works. So that would be my advice.
It's a real tension here, actually. It's a topic that comes up quite a bit at the Litigants and Personal Engagement Group about how you assist people with the technology without providing them with legal advice also. And I know that...
We don't consider that to be a problem at all. Like how you just help people. I mean, you just... The use of the technology is not legal advice, in our view. Is that what you mean by that?
I think it's because sometimes one of the things that's come out through the assisted digital strategy is that when people are asking you questions about how do I use the computer, but also what do I put in this form?
Oh, I see.
And I think one of the ways you may get around it is because you have great partnerships with community legal centres, am I right, that support people who need that advice, with the legal and the technological.
I think that's right. I think there's a few strategies. I think one, if you're testing it with real people, you can wear off those rough edges. So our forms are really, really simple because we test with lawyers last. We did this wrong initially. We tested with lawyers first, and what would happen is we'd have 30 lawyers in a room, and each of them would go around and say, well, in my 20 years of practice, this really weird thing happened one time, and it sure would have been great if there was a rule about it or some field on the form. And you multiply that by 30, and you have a 2,000-page user guide or a 2,000-page form. So we've learned, our rule is if something only happens 1 out of every 100 times, we're not putting it on the form. We deal with it through special handling. So simplified forms make it so that we get very few questions about that. Where we do is often very elderly folks, and because our staff, our frontline staff, are not doing data entry, that's done, they're not asking questions about how to fill in forms mostly, it's not unusual for them to spend an hour on the phone with an 80-year-old person who's struggling. And they won't tell them what to put in those fields, but they will tell them what evidence is, what we're asking, how they can get help, where to go. They'll give them phone numbers. They'll connect them sometimes to to pro bono organizations. And they can do that because they're not doing data entry, which also, by the way, makes them a lot happier as staff. Does that sort of... Maybe, I'm happy to chat later if I haven't quite answered your question properly.
You've done famously.
Okay.
Professor Resnick.
Hi, Judith Resnick. I wanted to ask Dory about your sense of both the failures and it intersects with the cross-border variation in jurisdictions and different people's, and also comes to the data question because of incompatible portals or data collection or the like. So one question is what are the ambitions in terms of harmonization of what a thing called a case is, or a tribunal, or a hearing, or whatever, in your many European jurisdictions. Mm-hmm. And so, at the front end, are you hoping that there will be one owned by Google, Microsoft, owned by whom, developing what software that will create uniform definitions, or will it be interfacing with the research that somebody else will have to interpret what constitutes these events that come to be understood as legal cases of some kind or pre-legal cases. So if you're trying to tell me that I'm going to learn about this system when I have a chat online, have I been to court or not been to court? And so I'd like to understand both of the ambition side and the failure, the challenge side, if not the failures.
Let me start with the ambition side. The European Commission's ambition goes only so far in that it's a very European solution. They have made something that can only work through the national judiciaries. So there is a portal, and your request, your claim form then goes to, let's say, a court in Italy or a court in Germany. And it's the national jurisdictions who then have to deal with your claim. So that was the easy part, and I'm not quite sure how I can answer your second question.
Well, if all the different jurisdictions are using their own different systems.
Yeah, that's how the European system works. Yeah.
And there's not an ambition to try to create harmonization of the database and information. We'll get back to the scorecard problem, which is I won't even know when I will count something as filed And if my metrics are all going to be about efficiency, I mean, the question, of course, is what if outcomes efficiency, what are my metrics?
Yeah.
So if the idea is there'll be 20, how many numbers will be there? There'll be more than 20 different counting systems. What will I know at the output side?
Yeah, that's exactly the problem I was talking about with the European Commission for the Efficiency of Justice at the Council of Europe. That's the problem they deal with. All those different systems. What do you want to know from those systems? And how can you make sure that the governments of all the member states are going to tell you what you want to know? And that's that's a concern for all of us. So that's why I said you have to be very careful using those data, because you don't always really know what you're looking at. And I'm afraid we can't make it any better than that right now.
Do you have time for one more? Yeah. So Professor Trinder, and then
I can hold it over until tomorrow.
what I think.
Just very, very quickly, Shannon, you mentioned the fact that the tribunal was moving into personal injury and vehicle, and that which are areas where the profession has previously had a stake. How's that going?
I'm going to think for a moment, so I'm diplomatic. Yeah, so it's early days yet. The legislation's gone through third reading, hasn't received royal assent, but it's headed there. We have your system of parliamentary legislation. So it is coming. The personal injury lawyers and the Canadian Bar Association, which is an advocacy group for lawyers, are both quite vocally opposed to the use of the CRT for these disputes. It's also come along with a cap on pain and suffering for minor injuries, so that's also been controversial. But we are trying to keep a clear-eyed focus on what our mandate is here, that we're being given by the legislature, and we're going to approach this area of implementation the same way we have the other ones. That is, focusing on advocates, focusing on human-centered design, rigorously testing, and being agile. So my executive team and I meet every 2 weeks, and we review 360-degree feedback. The stuff you saw from the stars and the emails, but also things our staff tell us. Our staff have a success wall of post-its where they've brought things to management and we've acted and changed it, and we do that in a 2-week cycle. So we take all of this feedback and we just change course. And I think, honestly, that's been the difference between success and failure for us. It's not that we haven't made mistakes. We've just made a billion of them, but we don't let them go on for very long. And we just are always course correcting. So we're going to keep on doing that, but the stakes are much higher. Suddenly, this is not the crumbs of the justice system anymore. This is the center of it. There were 16,000 notices of claim in the BC Supreme Court last year for motor vehicle disputes. 70 to 80% of those will come to us now. It's a massive transformational change, and I'm gearing up to do the kind of change management I had to do back in 2014 and 2015. But we know how to do it now. We don't take things as personally. Ego to the side, clear-eyed focus on the futures.
I suppose we better draw to a close. I guess 2 points that occur that perhaps we could think about tomorrow in the conference is when you're looking at the principles that drive the BC, the Civil Resolution Tribunal, and actually the principles under here, there's not a lot in either system about things that lawyers or jurisprudence scholars traditionally care about, so rectitude of decision or the rule of law. And I guess if these things that the public are saying they want from the justice system neglect those factors, what does that say about the job we're all doing about encouraging engagement with and understanding of law and legal process? I suppose the second point is when you have certain parts of the justice system that are user designed on the basis of feedback and other parts of the justice system that demonstrably are not. We don't crowdsource our laws. I don't think there's any intention that we're going to be doing this sort of work in the criminal, or maybe you guys do. Not yet. Does this create a tension because you have this sort of tension within the justice system? And when you're thinking about designing legal processes that are responsive, that are around people, do we need to think about a mandate to reform wholesale, including the legal framework? I guess those are 2 points that I'd really like to come back to tomorrow. Big points. So we'll solve it by tomorrow. But thank you ever so much. It was a fascinating panel and so grateful to panelists.